once again, welcome. This is going to be part 3 of what happened in Nashville, or what happened with the first encounter with legal issues from all this. And I left off with being at the state hospital, and now I want to finish up with the actual trial, or so-called trial. The whole time we were there, we refused to talk to any lawyers. Hauser, your lawyer's here? No, he's not, because I don't have one. That's what they were trying to do. The minute we talked to them, it was over. So we refused to do it. And as the trial went on, the lawyers would come in periodically, and they would go, how did we do? You got any questions? So the 4 of us were locked up, 5, were locked up in one little cell. There was a 70-inch flat screen right outside the doors of the cell. There were places or windows for 4 different camera views. They only used 3. Most of the time, the audio was out of sync or wasn't working at all. Sometimes the video was out. And the reason that was going on was we refused to go in. The reason we refused to go in was the very first day. The trial lasted for 5 days. All day. There were 27 witnesses. And in those 5 days, it was just the prosecution. That was 5 days of prosecution argument. There was an alleged 204 charges that had to be addressed individually. From what I understand, there was members of the jury, or the alleged jury, that were sleeping. It was boring. I don't blame them out of it. If they were there, I don't blame them, because a couple of us got bored and dozed off. Plus, we wasn't getting much sleep that night. By the time we get back to the jail, it'd be 10:30. And then it's up again at 4, They do that for you so that it messes with your deprivation. They're corrupt, man. These freaking states that do this crap, they're so corrupt, man. And we're the criminals. So they came in and they said, the judge said that you can come in and you can participate, but you wouldn't be allowed to say anything. Even if we hadn't challenged the jurisdiction, you're telling me that I can't go in here and say anything, right? Yeah, that's what she said. And the way that we did it is when one of our lawyers would say something, the one of us that they were trying to represent, one of the other guys would talk. So we never addressed the attorney that they had forced. Actually, the attorneys usurped power of attorney. They acted as if they were us without our permission, which is identity theft. Okay? Oh, they're going to pay. They're paying too. We just tried to help you. No, you didn't, because you usurped our being. And how dare you? They come in and they said, well, you can come in and participate, but you can't say anything. Well, if I can't say anything, then I can't testify on my own behalf. I can't question the witnesses. What? Well, why would I want to go in there? You're telling me right now you're going to violate a constitutional freedom? Right straight there? No, I don't think so. So the very first day, they, another thing too, they had a 4th camera place that was black. And they could have put a camera on the jury box, right? But they didn't. So we never seen a jury. A jury never seen us. wrap your head around this, folks. They had a 5-day trial that we weren't allowed to go into. And we seen no jury, even try how they were trying to do it. Oh, well, let's put it on the TV and we'll give them sound. And, at least we can say that we had them here. No. We saw no jury. No jury seen us. They had our 5 photographs on a big whiteboard. Big whiteboard. And all the jury had for reference was photographs. How did they even know we were real? At least they could have said, well, we're going to parade these guys in here so you can see that we do have a physical person. No, they didn't even do that. Then what they did, the very first day of the trial, Judge Judy said, asked every one of the attorneys, how does your client plead? Not guilty, Your Honor. Not guilty, Your Honor. Not guilty, not guilty, not guilty. Right? First off, they were pleading not guilty without our power of attorney. And think about that. If she's asking them, how does your client plead? Wait a minute, you're trying to say that the arraignment that you allegedly had 14 months ago wasn't a good one? That you're asking them now how we plead? And according to Tennessee Code Annotated, there has to be 60 days between an arraignment and a trial for summonsing the witnesses and pre-trial motions and such. It's the law in Tennessee that there has to be 60 days at least between a trial and an arraignment. So now if you're saying, how does your client plead? What you're doing is you're arraigning the day of the trial. What, the first one wasn't effective? You got to have one? So the trial went on, and the witnesses witnessed. My ex-wife was one of them, by the way. Many of the circuit court judges that I laned, I don't think any of the circuit court judges or the sessions court judge or the clerk of this county came to testify. There was 21 people that could have testified against me or against my trust that could have testified. Only 12 showed up to do it. The 9 people that didn't show up, there was 18 charges attached to them. Right? We were found guilty of all charges, even for the people that didn't show up. You don't even know if those other 9 people are real or not. And that was one of the arguments that they made in the sentencing phase and with the jury. And the jury, in 45 minutes, the jury found us guilty of all charges, the alleged jury, of all 104 charges. In 45 minutes, they found us guilty of every one of them. And like I said, I was sentenced to 20 years. One of our guys was sentenced to 50 years. They try to say he was the ringleader, without RICO Act, any kind of RICO Act thing. So, yeah, he's 73 years old and, and is not getting out till 2036 or something like that. Not even eligible till 2036. That's what it is. But that's all about to change. So they have this trial, and every one of these witnesses are asked, do you got a contract with these guys? Do you have a business arrangement with these guys? I've got the transcripts right here in a big old folder. I've read them over, and I know who said what, and every one of them said no. The lawyers wouldn't admit the conditional acceptance into the case. Because, see, the conditional acceptance is the contract that verifies everything. They tried to say that the UCC1 was the lien and that the UCC1 had value, $250,000 or more, $4 million, $12 million. They tried to say that the UCC1, which is a financing statement, it's not a lien. They tried to say, but they kept calling it a lien, even when one of the lawyer said, hey, these aren't liens. They're financing statements. They continue to call them liens. They put each one in a manila folder, and the judge wrote whatever the amount was in the description box of the UCC1. Case number blah, 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 amount number 4 million, defendant's name, and then here you go, jury. So they placed a value on the UCC1, which has no value. It's not even like a receipt to Walmart. You got something that you paid for at Walmart. You take the receipt back and get your money back. You can't even do that with the UCC1. It's just a notice that there's a debt that's owed. So, and they also had to be able to prove that we had intent to defraud. And if there's a contract, there is no intent to defraud. We told these lawyers, hey man, why don't you get the conditional acceptance into the case? The judge told us we better not even mention that. If we do, we're going to lose our bar membership. We're going to lose our license. Really. So what it came down to is the court or the judge wouldn't admit the contract into the case, because the minute she did, they'd have to argue the contract. And they couldn't say that we did it with ill intent. You can say that the judge could have said that the contract is a bogus contract, there's no legal basis in this contract, or however she wanted to say it. But if they could have argued that, jury, in order for you to convict, the state has to prove this. Can the state prove that these guys intended to defraud these people when these guys believed they had a viable contract with case law that said they could do what they were doing? But they wouldn't allow that argument into it. The minute they did, that would have fell apart. It's falling apart now. It's going in front of the Supreme Court. The Supreme Court Tennessee Supreme Court only hears 6% of the cases that's brought to it, and it overturns 90 to 95% of the cases from the Court of Criminal Appeals. The lawyer that's arguing on behalf of Mr. Hauser is super intelligent. This woman here has gone the extra mile to do this, and I commend her for it. I do. But, like I told her, I said, you don't have my power of attorney to do what you're doing. She came and visited me at the prison before I got released, and I told her, I said, look, man, I haven't given you any power of attorney. You're committing identity theft, and I will charge you when this is all over. Well, I hope you don't. I hope that you're happy with what it is that I'm doing. And, believe it or not, it is my intention to take this to the United States Supreme Court if I have to. I believe you. But I told her, I said, look, this is how this is going down. You don't have my power of attorney. But if you argue this the way I want you to, I'll give it to you. I said, I'll write the brief for the Court of Criminal Appeals. I'm here at the law library. And I'll write the brief, and I'll send it to you. And if you'll argue this the way I want you to argue it, I'll give you the power of attorney to do it. Even though I don't like lawyers at all. She said, well, I can't make any promises because I haven't read what you got, I said, okay, if you read what I got and you think it's a good argument and you choose to argue it the way I want you to, then you'll have my power of attorney. We got a verbal contract. She said, okay, it's been great talking. We talked for 3.5 hours in the prison, in the visitation gallery. So I sent it to her from prison, and then right after I sent it to her, I got released. So she calls me at the house, and she goes, man, she said, this is awesome. yeah, I'll argue this. She said, I'm going to make a few corrections with the legalese. And, but yeah, basically what you got, I don't know where you got this from, man, but man, this is going to look good. I don't see how the Court of Criminal Appeals cannot, overturn all this stuff. Well, she argued it, and they didn't overturn it. They decided to stand with the lower court, and we talked on the phone after I was out, and we talked about how to address the Supreme Court, and you know, what's your feedback? You know, well, argue it like we did before, but here's some extra stuff, and I shot it to her. And basically, what the state said that we did was filed fraudulent liens, and let's see here. They said we filed fraudulent liens. The one that they claimed, half of the ones that they claimed we did was, I probably ain't even gonna be able to find this now. One of the charges, there's so-called charges, yeah, it's right here, was Tennessee Code Annotated 39-17-117. It is a Class E felony for any person to knowingly prepare, sign, or file a lien or other document with the intent to encumber any real or personal property when such person has no reasonable basis or any legal cause to place such a lien or encumbrance on such real or personal property. Okay, real property is real estate. Personal property is property that can be moved. We didn't, in the description on the UCC1, the property that we liened was their trust, $4 million. Unless you got $4 million in gold or silver or fiat currency sitting around somewhere in a bag, then it's not movable. We didn't lien the real property. We didn't put any liens on their houses or anything. We just liened their trust. So with that deal, it's now in front of the Supreme Court. And yesterday I spoke briefly about that. And in the Supreme Court of Tennessee, they only want to hear the forgery charges, which are the 20-year sentences. The Class E felonies are only 2 years. My guys have been locked up for almost 5 years now. I did 3 years myself. When the court overturns this, when the Supreme Court overturns this, my friends are going to be released. They're going to be released. Shit. I'm trying to find this. I said earlier in a video yesterday that I know for a fact that this stuff these liens have value. They try to say there's, you know, that they're arguing that they don't have any value because they don't have the conditional acceptance to go along with that. But I received, while I was in prison, I'm going to put my fingers over my ex-wife's Social Security number, except for the first part. This right here was a letter that I received from a bankruptcy attorney in Greene County. This right here is a notice of Chapter 7 bankruptcy. Okay, my ex-wife that actually came and testified, and before they questioned her, they removed the jury from the room, and so that the defense could question her, and so that the court would know how the defense was going to do it and make sure that they were asking it right. So they didn't do it in front of the jury. They brought the jury in, and then they proceeded. But I liened my ex-wife for $4 million. And she went and filed it in bankruptcy. And while I was in prison, because of this document, while I was in prison, I started studying Title 11, the Bankruptcy Code. And I found some very interesting stuff in Title 11. Matter of fact, I read all 5 of them. They're all about that thick. So, yeah, if you have any questions about bankruptcy, holler at me. I read them all. So, I know more about bankruptcy than bankruptcy attorneys, I think. So this comes from a lawyer, a bankruptcy attorney, and down here you can't read it, but bankruptcy trustee right here at the bottom, right? So you got a bankruptcy attorney and a bankruptcy trustee. Right? It's a trust issue. Bankruptcy is a trust issue. So, I get a call I'm calling my wife on the phone, and she said, hey, there's a letter came in the mail. She said, I believe it's for you, but it's not addressed to you. The lawyer addressed this letter that he sent to sovereign citizens, and then my street address. It's from a bankruptcy attorney. Why are you sending? They have to notice the creditor in a bankruptcy. And it says that in a bankruptcy, you can't even schedule a fraudulent debt for discharge. You can't even schedule one for discharge, let alone discharge it. There's the scheduling. Order of discharge. Signed by this judge. Okay. The United States Code says that you cannot schedule a fraudulent debt for discharge. Can't do it. That means that when they scheduled this was a genuine, debt. And then it goes on to say, in the United States Code, Title 11, United States Code, subsection, what is it, 329? Shit. I got it written down here because I wanted these. This little packet that I'm flipping right through here, friends, is the one that I sent to the tax court. And in the next video, I'll get into that. But in here, it says, that, title, I'm not even trying to look for it, I'm wasting time. In the United States Code, I believe it's 329, section 329 2B, it says that only provable debts can be discharged. Okay, so if the federal court discharged this $4 million debt, then it's a provable debt. And if they scheduled it, it's not a fraudulent debt. And that's where I have, if the debt with her can be discharged, right? Only debts, the only debts that can be discharged are debts with contracts. Okay, there has to be a contract. You can't owe me money and go in there and say, I owe this guy money. And them go, well, they're going to go, where's the contract? Well, I don't have one. I just owe him the money. Well, no, you can't schedule that. There's no contract, no debt. So it got discharged. That's the federal courts discharging the debt. Well, if her $4 million is a debt, then the other 14 people that I liened for $4 million, I didn't really lien them. I say that. It was the Treasury that liened them, and I'll get into that in this next video. Tennessee said we liened them or did some lien process stuff, We didn't lien anybody. The Treasury did. Jacob Lew of the United States Treasury liened on everybody. So the debt is genuine, and that's where this is all going. And we'll win. You know, I've already got proof that it's a debt, a genuine debt. And in this next video I'm going to do is going to be explaining what happened with the IRS and the bankruptcies, and they put liens on me. Property lien. They put property liens, froze accounts and stuff like that. But I'll get into that in the next video. Peace out.